Welcome back to our series on GenAI contract terms. I'm Deirdre. Today's topic is the Authorised Use Policy, or for short, the AUP. Policies describing prohibited activities in connection with the use of technology have been around for years, but GenAI and the various regulations applicable to AI and general purpose AI models means that the AUP is now a key part of any GenAI contract and can no longer be dismissed as just a policy document. It's worth remembering the following. The purpose of the AUP is to list out those prohibited activities, and providers are using AUPs as a way to ensure they can comply with their obligations under legislation, particularly where prohibited or high-risk use cases exist. As a result, from the provider's perspective, the AUP is really a critical document and it's designed to limit and mitigate risk. AUPs now form part of the contractual terms. They are binding on the customer, and providers are typically asking for uncapped liability, often on an indemnity basis, for breach. They're also typically standardized across customers and presented as non-negotiable. However, we do recommend that they're checked against the contract terms to ensure that there are no conflicts or inconsistencies, particularly if the parties have negotiated deviations to the provider's standard terms. This is an emerging area, and providers' terms are frequently updated as market practice develops. We therefore recommend that you revisit those existing terms each time your use case changes, or after specified periods of time, or when the provider tells you they've updated the AUP, and if necessary, reopen discussions and request appropriate amendments. For more information on all things GenAI and tech law related, please see our vlogs and blogs. Thank you.